Good morning. Normally, what happens when after obtaining loan, uh, the financier used to sleep over, or the person who was engaged to defend his case would not have been properly approached. So, the debt being subject to bar by limitation. Under that circumstances, what happens? The financier used to fabricate documents with the papers which was available with him by bare signature. They used to fill up as if he acknowledged the debt and extending the time for payment, and also part payment was paid and extension of period, and claiming that a period of limitation would run there from the date when part payment was paid or from the date acknowledgement of debt was. The question of acknowledgement of debt is not properly appreciated by the lower court because summary chapter suits are being filed and it is being decreed without going through the papers. But stamp duty, the description of Indian Stamp Act about acknowledgement of debt shows something different. But here, section Limitation Act, question of Limitation Act 18 and 19, that is speaks about totally different. So, the Andhra Pradesh had an occasion to discuss with this sort of cases. This is AR 2026 Andhra Pradesh 32. AR 2026 Andhra Pradesh 32. K. Nagaraj versus Andhra Pradesh State Financial Corporation. So, State Financial Corporation seems to have issued a legal notice under 32G for realization of debt. But the ratio of the Andhra Pradesh division bench was recovery of amounts due, extension of limitation, part payment or acknowledgement made after debt has already become time barred under Limitation Act does not extend period of limitation. Therefore, plea of AFSFC Andhra Pradesh State Financial Corporation that even if it is presumed that debt is barred by limitation, payment of 2,000 made by petitioner towards part payment of due are covered under loan account of respondent would extend period of limitation, and fresh limitation started from that day was unsustainable. To this extent, I will close the judgment. So you have to verify whether what was the original date of debt, what was the period of limitation, 3 years period of limitation. If that is already been expired, the part payment subsequently obtained and the acknowledgement of debt subsequently obtained would not come to the rescue of the financier. Therefore, the seeking for extension of limitation under section 18 and 19 of Limitation Act would not come to his rescue if the bad debt was already time barred. So under those circumstances, we should carefully go through the documents and at the time of giving reply also you can very well state your all defenses. Just like FIR, legal notice is not FIR. The FIR is hurriedly being lodged, therefore it is not substantial piece of evidence. But legal notice as well as reply notice is not being given hurriedly. You can very well collect your instructions, apply your mind and give reply properly so that your automatic defense in the written statement would come. So for civil cases, you always must concentrate on Indian Stamp Act, Registration Act and Limitation Act. All these things would definitely help you. And Interest Act. So there are Interest Act deals with certain provisions where exorbitant interest may not be, and the source of income of the Financier must also be looked into. Best wishes.